Good morning, everyone. Thank you for joining today's webinar. We would like to give a big thank you for our partner Idea to IPO for organizing the webinar. This is the second series of the webinar, how to move the company to the United States. The first initial webinar was more theoretical. Now we would like to take a more practical approach. And we would like to present to you all kinds of documents that you need in order to move your company from overseas to the United States. At the same time, we would like to interact with you by asking questions where you're located. I would encourage everyone to submit questions here to Q&A in Teams application. We encourage everyone to respond to our questions in the poll that are going to be presented shortly. And we would like to have a casual conversation with you while the presentation lasts. So we will know more about you. We would like to get more details about your team, about the product. So please don't hesitate to participate in this conversation. This meeting is recorded, so everything will be recorded. So be careful about sharing any confidential information. After this webinar, we will be happy to share with anyone the materials that we have. And if you have any follow-up questions, we will have information at the end of the presentation with our emails and LinkedIn information. Today, this presentation, Primum Law Group, the partner of the firm, Svetlana Kamyshanskaya, founder of the firm with 20 plus years of experience working with startups, helping them with corporate law, corporate governance, different transactions, and just questions about intellectual property, employment, and everything else that company needs in order to have happy life here in the United States and overseas. This is me, Lina Firsava. I'm a corporate attorney at Primum Law Group. I help companies with basic drafting, explanation of different types of documents, daily communication, I work on transactions as well, and just main point of contact in any communication. So we would like to ask our team members here, Gloria, to present the polls to the audience. We will be asking you to provide answers to 2 questions. The first one is, where are you located? Please respond. And the second one is, at what stage of financing your company is right now? If you're not sure what stage of financing means, we prepared a question for you. I don't know. We will understand that you need some help with explanation what financing means, which rounds are there, and we will be covering this later in this presentation. So let's see the results of the poll.
Wonderful. Elena, while we are waiting for the results, just add a little bit. So as Elena rightfully pointed out, we had a series of webinars where we explained different considerations, how to bring the companies to the US. And this is a first session where we decided to build the program more like a workshop. Luckily, Universe helped us, so organize Idea to IPO, change the date, and it looks like we lost a lot of people in transition from one day to another. So we don't have a lot of attendees. It's a relatively small group of people. I would appreciate the conversation. So I would start with a little bit of introduction, and we want to move forward to your specific scenarios so we can kind of demonstrate how it works in a different type of scenarios, like whether you're in Europe, Asia, what are the considerations there? That's why we are asking, and we need to understand what continent or country you are at, and what is the stage of the company, so we can be more effective in providing you materials that we have.
Yes, we will now see the results of the polls. I will answer too, so I see the results. It looks like we don't. Yes.
Just so you know, we only have 3 responses so far.
And one of them is mine, right? Okay.
Yes. We have 4.
Oh, okay.
Okay.
I see people as well. Yeah. Okay.
So the information is necessary again to address to be more precise in providing information. So it would be more. Someone is raising hand.
Would you like to take the question right now?
Yeah, like.
Okay, Amelia, can you please unmute yourself and ask the question that you have?
Okay, we cannot hear. Do we have results? Like how many people submitted the poll?
We have 4.
Okay.
Okay, this is how statistics work. It doesn't matter what is the number. Usually it's going to be the same. So let's see. I think I see the equal separation between the US, Europe, and Asia, and the most popular answer in terms of the stage of financing is I don't know. So people do not know at which stage of financing they are. More likely, it means that people did not raise their money. So we're happy to help everyone to understand what does it mean and walk you through the process of organizing the company in the United States. See more people are joining, but I guess we will end with the polls and move forward with the presentation. So as Svetlana mentioned, this is the last series of the presentation, how to move your company to the United States. The next step would be the preparation for the webinar, for the workshop, where we will announce it later in our LinkedIn page. We will create a certain application for founders from different countries, from the United States and from overseas, where we would ask everyone to submit information about the team, about the founder, about the product, about the stage of financing, and we will elect the companies to participate in the workshop. In this workshop, we will be having an online small gathering with our team, where we'll be walking through your documents, explain what do you need to do in order to successfully raise capital in the United States. We will explain how to raise capital, what are the ways in raising capital. So please stay tuned with our announcements on LinkedIn. We aim to post this webinar in September. In the meantime, we will be moving forward with more theoretical explanation of what do you need in order to move your company to the United States. We assume that all people that are presented here are founders of the companies overseas, and in order to move forward with explanation on what do you need to do in order to move the company to the United States, we need to understand the reasons why you're willing to move the company to the United States. So there are several reasons why people are willing to move their company to the US. The most common is to raise capital, explore US market, have access to a specific unique talent of Silicon Valley, for example, and all of the above. We saw companies, in particular our clients, who were willing to pursue all of the above, but when people are willing to raise capital, hire someone here, and expand to the US market, we expect them to already raise some money overseas. If you are in the beginning stage, if you're just looking at the opportunity to move to the US, we're happy to present the checklist of the documents and cover the steps that you need to finalize in order to be able to start incorporating in the United States and move your company from overseas to the United States. Svetlana, I'm presenting the checklist right now, and we will walk it through it.
Yeah.
So
can I just jump in? So basically what we are saying right now, what Elena started to explain, regardless of the reason why you're here and regardless of the reason why you decided to move your business to the US, we need to start with the company formation. And yes, there are many different considerations for the process of the company formation that we have to discuss down the road. But in any case, you have to have an entity in the US. And the list that Elena presents, and she's going to walk you through the list, is the list of documents that have to be available in order first to consider the company to be formed, and second to expect the least amount of legal issues related to the company formation itself. And of course, that form company provides you more liability protection and provides you the option to go and raise capital. So that's the first step that you have to do is to form the company. So as Alina walk you through the list of documents that have to be available for that have to be drafted and executed in the process of the company formation, you would understand more. But after that, I want to kind of piggyback and explain what are different considerations that we have to take in or keep in mind while we are working with this specific client and forming the company. Okay.
Before we begin, I would like to let everyone know that we're happy to share the materials. So this presentation will be available in the email afterwards. This is basically the company formation checklist, and our firm and people here from our team are helping you with facilitation of the process of drafting of these documents, filing of these documents with necessary authorities. Before we proceed forward, and I will explain what each step in this checklist mean, I would like to ask the audience to raise their hand, like in Teams, and explain maybe to everyone who is ready to move forward with incorporation right away. Like who is at this stage that they're ready to move forward with incorporation in the United States within like a few weeks, to see if anyone is ready. If everyone will be hesitating, we will understand you and we will just move forward with the checklist. Okay. I see one person rose their hand. I would like to give you an opportunity to just briefly present yourself and where you're located at. If you don't feel like doing this, that's fine, but you can unmute yourself and just give a brief overview about you and your company. Okay, I see another person. Let me unmute you.
Sorry, I couldn't unmute myself. I was a little bit late. Thank you for giving me the opportunity to speak. I do already have a business, and that is what I do want to move to the States. That's why I said that I already have the documentations ready to be able to move. It's about real estate.
And where is your original, like, what is the country of origin of this business?
I am in Helsinki, Finland, and my market is going to be Los Angeles and Texas.
Okay.
Okay, that's a good example. So, Elena, I suggest still like through general, and we'll jump to discussion of this specific case later.
Okay.
Thank you.
Thank you, Huda. Yes. So let's begin with the incorporation matters. This company formation checklist is extensive. It will cover, in addition to the incorporation matter, other matters regarding capitalization, employment, and intellectual property, but I will begin with just general overview of the incorporation matters. So when you decided to form the company in the United States, the first step is to decide on the company name. And when you decide on the company name, it's important to check whether this name is available. That's why Primum Law Group, we help you with reservation of the corporate name. It means that we go to a specific state. It can be Delaware, it can be California, where we check whether the name that you chose for the company is available. In most of the cases, name is available, and we proceed with reservation of the corporate name. Then we move forward with preparation of certificate of incorporation. Certificate of incorporation is the legal document that defines the legal entity. It's a constitution of the document, like passport of the legal entity, I would say. In different states, there are different names of this document. It may be called Articles of Incorporation in California and Delaware, Certificate of Incorporation. This is the main legal document that sets up the company name, the registered address of the company, the number of shares, you are reserving and authorizing for your company to issue, and all other significant details about the location, the purpose that are necessary to be included in this document. Usually it's one-page document. It's available online on each state where you registered it. The charter, the core document of the corporation is its bylaws. If you're organizing limited liability company, it doesn't have bylaws. It's called operating agreement. But since it's a company formation checklist, we're covering the charter document as bylaws. So what's bylaws? Imagine you created your company, you registered your company, but you would like to create a set of rules, rights of how your company needs to operate, what are the internal rules, and explain the corporate governance structure of your company, who are the officers, what is their authority, etc., etc. For these purposes, you have to have bylaws. It's not a mandatory document to operate the company, but we facilitate with the process of organizing this document. So you have an internal set of rules that helps you to communicate inside of your company. The next document is just one of the procedural documents, is action by incorporator. Usually we sign this document. Incorporator is the person who technically tells to the state who will be the board members of your company and approves the execution of the bylaws of your company. So it's just one of the procedural documents that needs to be finalized in order to start. The main core document is organizational board consent. Let's just cover a little bit what board consent means, so you have a better understanding of what needs to be done. Imagine you already picked the people who will be serving as directors of your company. It can be one director, two, three. It can be any number that you put into your bylaws and approve with board consent. These people, even one person, will from now on form the board of your company. Board is the operational board of the company. It's basically like the main core instrument of people who decide on all operational matter. As you already know, a company has shareholders. It also has directors. Same people can be directors and shareholders of the company. So why do we need to pass the board consent? Every significant decision of the company needs to be facilitated by the board. So if you are willing to decide on something going forward, you will be passing this board consent. And organizational board consent helps you to I would say explain to your own company that you're approving the bylaws, that you're appointing officers, that you have registered address, that you approving certificate of incorporation that you filed, and that you're giving authority to several people, usually it's a chief financial officer and secretary, to open a bank account for the company. So basically you're just approving actions that you already conducted here in steps 1, 4, 3, and 5. So this document needs to be signed by the board, but we facilitate with the process of drafting of this document. We present it for you, and you just need to revise it and execute. The next very important step will cover the resolution of tax questions that company may have, and this is a preparation of the filing of SS4 form. So what is SS4 form application stands for? Each company needs to have their unique employer identification number. It's called EIN number, which is important from a tax standpoint. So you will be needing to have this number in order to submit and facilitate all processes with IRS, Internal Revenue Service Department, and all like tax related questions, all like process of hiring employees, opening bank account, making any different filing taxes necessary to be conducted using this number. We see that a lot of people here, we hope a lot of people here allocated overseas, outside of the United States. So the process of obtaining employer identification number for you will be slightly different, because the main document that you need to have in order to obtain EIN number is Social Security number, which is the number that only American citizens and permanent residents have. For this purpose, there is a different application for a specific number that's called ITN. It's Individual Taxpayer Identification Number that you need to apply for and obtain in order to be able to like prepare a file this form. So basically, we are helping and facilitating the process of obtaining the ITN number for all foreign founders who needs to later apply for employer identification number. The process is quite complicated to understand, so we are happy to take these questions after the webinar. You can just present them to Q&A and we will cover them after this presentation, after we cover this checklist. The next step is preparation and filing of qualification to the business as a foreign corporation in the states in which the company is located. So imagine you decided on the state where you're willing to incorporate. Most of the companies usually go with Delaware, but we saw several examples among our clients, among other people who incorporate their companies in different states. Usually the state of incorporation and state of operation is not the same state because you incorporate in the most like pleasant state for you, in the state where you have additional benefits for your company, but you operate in the state where most of your people located, your employees are located, your operation is located. In order to do that, you need to file a specific form, which is also part of this checklist, in order to facilitate the process of operation in this state. So usually this form is filed in California if you're operating this business in California, or in Nevada if you operate this business in Nevada. We help with preparation of this form and filing of the form with designated state where you're willing to operate. Organization of corporate records and minutes books is the next step. So what we would put here is, as a firm, we keep a special cloud for our clients where all of the documents that we drafted for you, that we filed for you, that necessary for you to have, we keep in one specific place. All companies are advised to have their own corporate record and minutes. This is basically the electronic library of all documents that you need to have, that includes everything drafted already, maybe stock ledger, where you explain who owns what number of shares, names of people who are the shareholders, etc. It's just, it's not mandatory, but it's easier to be informed of all decisions that company made and demonstrate a good level of corporate governance. The next document is a very interesting document because, as we learned from our clients, and not many founders know what indemnification agreement means, how it's helpful for you, and what the results can be achieved by drafting this document. So we always advise the founders of the startups to have an indemnification agreement. Basically, it outlines the corporation's commitment and decision to protect directors and officers from any personal liability while they perform their duties. So what does it mean? As director, officer of the company, you are the key person to make decisions regarding the operation of the company. But this indemnification agreement means that the company of whom director you are will protect you personally from liability if the decision that you made is not correct. It doesn't mean that you will not be liable for anything that you conducted in your company, but while performing your official duties with respect to all rules, with respect to all obligations that you need to respect and facilitate, if you did everything diligently, properly, the corporation will protect you as officer and director of the company. So we prepare these documents for you, you revise them, you just sign and execute, we prepare and everything is ready for you. Usually we support this document with stockholders' consent approval. So stockholders' consent is the same as the board consent, it's just approval of the shareholders versus approval of the directors, where we ask stockholders of the company to approve and to facilitate that they're fine with approval of these indemnification agreements. Svetlana, I would like to ask you if you would like to add anything here.
Yeah, I want to kind of stop here before we go to capitalization. So I want to add a few points here. First of all, I want to emphasize that the process of the company formation consists of two parts. As Elena said, first you file the certificate of incorporation with the state, and then you prepare the rest of the documents, meaning you prepare the initial resolution, you elect the board members, officers, and prepare the documents that Elena just listed. I see a lot of cases where founders come to me and say, okay, we have a company formed, we took money from investors, take a look what we have before the next round of financing. So basically, when companies take first capital from angel investors don't check the record, and before raising something serious, they come to the lawyer to check if they have everything in place. And what is happening is that those founders usually they use LegalZoom, or they use accountant who formed the company, or someone else. So they have certificate of incorporation that was filed with the Secretary of State, and that's it. In the best case scenario, they have EIN number because they needed to open the bank account, and you could not open the bank account without having an EIN number. If the lawyer was not involved in the process of company formation, usually companies don't have the rest of the documents listed, in even in the first part. Like, we didn't discuss any distribution of shares yet, and the capitalization, and etc. So companies don't have formal documents appointing officers and directors. And in most cases, they don't have documents distributing the capital in the company. And when we clean up, we have a service of corporate cleanup. Usually it takes more hours and it's way more expensive to clean the stuff than to form it properly in the first place. So that's just one thing that you have to keep in mind. But since we are talking about bringing the company to the US, from the foreign jurisdiction, I wanted to touch base a few considerations that we have in place when we discuss the company formation process. So first of all, we definitely discuss with founders why the company is coming to the US before we file the certificate of incorporation, because it's important to define the right jurisdiction for the company. As Elena said, a lot of companies are registered in Delaware. And the reason of registration in Delaware is not because it's offshore jurisdiction, as many of founders mistakenly believe. The reason is that Delaware has the most developed corporate law in the US. Delaware is the only state that has a corporate court, and because of predictability and the developed law, investors like the jurisdiction. So basically, when you're registered in the state of Delaware, the investor feels comfortable operating and like using Delaware corporate law, because first they know that, they know how it's going to be resolved. There are many precedents, there are many investments made in that state. So there is nothing that you have to create or build a new bicycle. So no one wants to do that. So then we formed the company in Delaware. But there are companies that don't want to be present even in the US. So they set up the companies just in order to expand to the market and use Amazon as a platform to sell goods in the US. And in this case, you don't need to go to Delaware, and you shouldn't be registered in California as well. So for this type of scenarios, we suggest Nevada or Wyoming, because they don't have state taxes, and it's just a very convenient state to be registered in. So I'm bringing it up to emphasize that it's important, even at the stage of the filing of the certificate of incorporation. It's one thing that you could do it yourself, but you have to really pay attention what state are you filing that certificate, because it really affects your ability to do one thing or another, or like ability to optimize taxes down the road. And Elena, if you don't mind, I'll move to capitalization matters. That's the second part of the company formation process. Is distributing equity among founders, or like another way to put that is selling shares to the founders. So basically, during this stage, we allocate shares of the company to the founders of the company. And here we have other considerations to think about. First of all, and we always ask, like, what do you bring to this company? If you already have existing product, maybe you want to contribute this product to the company as a consideration for the shares to be issued. Or another scenario, like if you have already existing company in another jurisdiction and we are planning that the US company is going to be headquartered, maybe the consideration is going to be shares in the entity that already exists abroad. And so those are just two scenarios that are most common. And again, like before you do that, you have to think the process through. And if you don't do that, there are consequences, and the consequences are taxes. So why we are thinking about contributing the foreign entity as a consideration for the shares in the American company is because if you do it later, you're going to pay taxes. The same is going to happen with IP transfer to company after the company formation, because company would have to recognize it as a kind of profit and pay taxes on that. So you don't want to create these situations when you increase the tax burden just by not thinking it through in the beginning. And that's why I'm saying, although the company formation process looks very simple and it could be done quickly, if you don't approach it in the right way, you don't just create mess in your corporate record, you can trigger other consequences. And taxes is one of those that uh, no one wants to trigger. And here I wanted to go back to our brave founder, Emilia, who wants to bring a company from Helsinki and discuss one scenario just for uh, better clarity of all participants, how it's going to work in this case. So, Emilia, like to the extent you're comfortable sharing confidential information, if you give us an idea what exactly you want to bring to the US, so then we can give you like a little bit of debrief of what has to be done.
I think we created a little bit confusion. It was Hora who was sharing everything, so I will allow Hora and Amelia, both of them, to speak, and then we will see who is the bravest person here. Yeah.
Sorry.
So you can, ladies, now unmute yourself and present more information as discussed with Svetlana. Yes.
Sorry, should I speak now?
Mm-hmm. Yes. Hi. Hello again, Hora. Yes, we can hear you.
Could you please tell me the question one more time? I got confused because you mentioned Elena. I was not listening. Like, yeah, I'll have to answer.
Oh, okay, sorry. So I'm saying, like, we're discussing different scenarios of bringing company to the US. And I said in some cases, people have existing entity in a different jurisdiction and thinking about the US as additional market. In other scenarios, people have product and they want to bring this product and raise capital. So if you give us a little bit more information about your specific and unique case, maybe we can kind of use it in an example.
Of course, it's an innovative product. So it's a new product that's going to, I'm looking for growth. So I'm looking for a fast growth, and that's why I'm using the US market. So
do you sell this product anywhere else?
no.
Do you produce this product? Is it ready, or
Yes.
it's just?
Yes.
So it's not prototype. It's something that already.
It is going to go through some prototyping still for some research and development of the market, but the product can also grow. Of course, it's not going to. It's a flexible for the moment. I cannot talk about it exactly because it's a little bit of a stealth.
I don't want to. Yeah. But tell me a little bit. So you are not bringing the product to sell right now. So that's not the reason why you want to raise capital. Is that correct?
Exactly.
Okay. So, and that product, was that product developed in different jurisdiction?
Yes, outside of the US, of course.
And did you have a company in another jurisdiction?
Yes.
So this is like exactly the scenario that I kind of briefly discussed. So basically, if you had if you have a company in different jurisdictions, that company most likely paid to engineers or like someone who
Exactly.
developed the product, right? So who came up with that idea. You already had expenses, so you paid for that. Now, and most likely you had contracts with those developers. So now the product belongs to like the company that exists in different jurisdiction owns the product. In order to make this product like to attract to raise capital in the US. So basically you have to form the company. But if the new company is not owning that product or intellectual property, it's not interesting for American investors. Why would they invest in the entity that doesn't own anything? And in this specific scenario, the owner of the intellectual property is the foreign company. So what is happening in this type of scenario, we say, okay, that's fine. We have that foreign entity. Let's contribute equity in the foreign entity to the capital of the American company. By doing so, we optimize, like we make it very simple from the tax standpoint. We form the Delaware corporation in this case, and the foreign entity becomes a full subsidiary of Delaware company. In this case scenario, when investors come, uh, they can track the ownership of intellectual property. So it's another question if we're ever gonna transfer that. But the point being is that the entity that you're gonna form in Delaware is gonna own something, and that something is intellectual property that could be in, interesting for American investors. And if you don't think through the process from the get-go, there are many mistakes that could be done. So you would form Delaware company, distribute equity. Now you have two parallel entities, and the American investor has no way to reach foreign entity. And basically, in the beginning, to be fair, they're not interested. So there are so many American companies that are formed properly and have products. So why would they go through the hassle of investing in different jurisdiction if it's like very early stage company? So that's kind of a very,
So
very,
your recommendation is that I should start a new company in the US. Is that what you're like in a nutshell?
yeah, that was the recommendation from the get-go. As Elena said,
Yes.
when you come to
Mm-hmm.
the US, whatever you want to do in the US, you would
Mm-hmm.
not be able to move forward without forming company in the US. And I should be very explicit here. I'm not giving legal advice because it's a webinar workshop. So we are just discussing different scenarios. And of course, in order to be more precise, I have to really discuss in deeper details the situation. But yes, you have to form the company in the US because otherwise you would not be able to raise capital
Thank you very much.
stages. Yeah.
Thank you,
Uh,
Hoda, for sharing. Shall we move forward with explanation of more capitalization matters? So would you like to discuss the premium proving process in details right now?
no, I want to go through the process and the rest of the checklist that we didn't cover yet.
Right.
So we discussed the capitalization from the standpoint of distributing equity among founders, but there is one document, 83B form election, is a document that like I want to explain a little bit. So when you form the capital and you distribute equity, there is one vehicle that could make it more predictable, like make the process of development and growth and collaboration among founders more predictable. And that's vesting schedule. That means that if there are 3 or 4 founders today and one of them leave tomorrow, you shouldn't, that one that who leaves should not have equal amount of equity as those who stay in the company and continue developing the product. So in order to prevent this type of unfair scenarios, legislature was created, and we have that vesting schedule opportunity that allows company to buy the equity back. So let's say there are 4 founders, we distributed equity equally, everyone has 25% with vesting schedule for 4 years, meaning that everyone would get 1/4 of 25% of the company a year. And if they leave earlier, that means that the vesting is not gonna continue, and the company will be able to buy back unvested equity. An 83B form is the form that has to be filed to IRS for the like tax purposes. Basically, it gives some tax benefits. And that form is filed only if you use vesting schedule for the equity. Last 2 sections of the checklist are about employment or consulting arrangements with your like employees, developers, contractors, depending where you are. You have to have agreements with them, like whoever work for the company, especially if those people are involved in the development of intellectual property. You have to have first arrangement with them to make sure that you defined first the scope of work and the compensation, so no one has any potential claims. And the last section is intellectual property matters. So we need to make sure that assignment of intellectual property happened, right? So you have an agreement, whether as a part of the consulting agreement, as a separate agreement, and you have confidentiality or non-disclosure agreements with your contractors or employees. So the company has to be protected. And from experience, I can say that the more successful you are, like the more capital you want to raise, the more analysis is going to be conducted on your documents, meaning that the venture capitalists are very well educated and they want to negotiate the deals. And of course, if they invest into company, having in mind investment into specific technology, they want that technology to be protected. And if there are holes in your process, then when you cannot identify who specifically developed this type of, like this piece of IP or this piece of code, the deal is going to be like either negotiated not in your favor, or it's going to fall apart. Does anyone else wants to discuss this scenario? So we have 15 minutes. I think we can take 2 more people at least.
Just raise your hand, please, in Microsoft Teams so we can understand that you want to speak. And I also encouraged everyone to ask their questions in the chat as well. Okay, I see one hand. You can now unmute yourself.
Perfect. Can you hear me?
Yes. Hello.
Perfect. So, hey, my name is Yassis. I'm located in Germany, and pretty much we're on the early stages of our build, and we are on the MVP base, and the goal pretty much is to start reaching out for investors, right? And in this case, our scenario is that we have part of the teams, of course, my co-founders here in Germany, but some of our potential benefits of moving there is basically comes down to our use case or our company product. So we are a software product. We are creating an AI platform for B2C and both B2B. And so the question, or in the scenario in this case that we're faced with, is do we go into basically, first of all, we are rolling out the MVP bootstraps. So that means we already having some users, but still no focus on generating revenue at the moment. And then the next step is basically just generating traction enough to go to investors. So my question would be, in this case, from my own scenario, would be, at which step is it mandatory? Is it before getting the investors or after getting the investors? Because again, this is a seed round, so very, very early. And that would be the question. And the second question would be, how much of these are needed early, like from the get-go, you know, or are they used like in a step-by-step thing, so you don't get to establish everything from the start, especially as there is no revenue as seed round, or it's really necessary to do that. And then maybe the last step is how that works into moving into the country and starting like a startup. Is there some requirements revenue wise from the US government into that?
That's
Yeah.
good question. Okay, thank you. Sorry. So let me clarify. Do you have a company in Germany?
Not yet.
So you're
And
just a group of founders that develop the product.
correct. My goal is to start it in the US directly.
Okay, so to your question about when to form the company, regardless, whatever you decide, you would not be able to take money before you form the company. So you can go to investors right now and have them commit to invest, but they're going to ask you, where is the company? That's number one. The second part of the question is, do you really need everything related to this list? This is the simplest way. As I said, you can start with certificate of incorporation, and if investors don't ask anything else, draft everything else down the road. But it's going to be most likely more expensive because you would operate the company. You would make mistakes already. So it's very difficult to explain it within 3 minute span. But basically, if investor doesn't ask and you're willing to raise capital, potentially you can raise capital with only having certificate of incorporation. Another question is how many problems you can create by doing so. And I'll give you a very simple example. What if one of your founders will leave tomorrow? Like, how are you gonna split equity in that company? When are you gonna decide on that? And what if one doesn't do what he promised to do? And what if another one leaves the company and said that I'm not interested in this product anymore, and has some expectations from the company? This is the just basic issues that can arise. Another question, it really depends on sophistication of investor, but if investor more or less sophisticated, they would ask who developed the IP. And if you develop the IP and you don't have any agreements between the company and those developers, even if developers are founders, that means company owns nothing, and therefore investor invests money in empty entity. It's not really an attractive offer from that standpoint. The last thing, immigration. There is no immigration to the US using specific investments, like investment-based immigration is not really, I mean, in the sense that you use that, it doesn't exist. So there are visas for people with extraordinary abilities that founders use, or visas. But in any case, we recommend having discussion with the immigration lawyer prior to the company formation. And we usually have the joint conversation with founders when we can figure out what exactly could be used from immigration standpoint, so we can adjust the company structure accordingly.
Okay. So that's good information. So that should be taken into consideration while building the formation and the documents.
Yeah, it's important because sometimes there are specific requirements on the ownership of the company. Sometimes there are specific requirements on the link between a foreign company and American company. So we have to discuss it before company formation.
Okay. Is this something that you also offer, or is that would be like a separate immigration lawyer?
We do have immigration specialist.
Okay.
Thank you, Yasser, for being brief and presenting your case. Since we have only 10 minutes, I think we will just move forward to the section of information where any of you after this presentation be able to reach out to ask any specific questions you have. And on the next slides, I will present the information about our company, our firm. And if you're willing to request a consultation, please feel free to reach out. And our team here, Gloria, Kathleen, will help you to address any specific questions you have. This is the brief overview of how we work. We have a defined process. We will not be covering right now in details each step we take in order to facilitate the process of consultation and helping you to expand to the US. We will just explain that we encourage everyone to reach out right now to this email, and the first 5 people that will reach out will be eligible for free 15 minutes consultation. If you have any additional questions, reach out to this email, our personal emails, or LinkedIn information as Gloria shared in the chat. I see that, let me see. No one asked any questions in the chat. So we are ready to wrap up unless anyone is willing to raise hand and ask any additional questions right now. Otherwise, we are happy to see everyone in our emails. Let me go back here probably. And yeah.
Gloria has a question.
Okay, let me.
I didn't want to cut you off or anything, but I do want to
okay.
add that if you want to reach out to us for a consultation with any of our attorneys because your specific question hasn't been answered, you could email us at the email that is on the screen right now. And then I have also added the link for our intake form in the chat as well.
Yes. So Gloria attached our intake form. We ask everyone who is interested in consultation to fulfill this form. So we will have additional details about you and your company in advance of the meeting. So we will be able to address all questions you have during the consultation properly. Thanks everyone for their time. Thank you, Svetlana. As I mentioned, stay tuned for information about the workshop on our LinkedIn page. And thank you for your participation today. Goodbye.